firm concentrated in men's and fathers' rights in divorce, custody, and family law matters, with offices in Nutley and Montclair, New Jersey. Today is January 14, 2019. I am doing my how-to series, different from my daily tip. My how-to is a little more in-depth, try to give you just some helpful advice about a larger topic than I generally do in my how-to or my daily tips. I was out last week, so I figured I would start this week with the how-to series. Today's video is about how to prepare for a restraining order, a temporary restraining order hearing. And the idea of this video is if you're defending on the restraining order. So if you happen to be the plaintiff or the person that filed it, I was going to say probably doesn't apply to you. I guess technically it would. You would just kind of have to reverse some of the things I'm saying, but I guess ultimately it probably actually would still apply. So that being said, there's really, I think, three main things that anybody needs to do, and this is whether or not you have an attorney or not. If you don't, certainly more important, but even if you do, I think these tips are going to apply. First is to become familiar with the law. Now, there's always a lot of legal areas to any given case. So I don't expect you to go out and study everything and learn everything, but you want to learn at least what the person who filed the restraining order needs to prove. For instance, in New Jersey, they have to prove an act of domestic violence occurred, and there's 10 or 12 different criminal aspects that are tracked into the restraining order statute that they can use to rely on. So it has to be one of those. I think it's 12. So you want to first find out what has to be proven to establish any one of those 12. And they also need to prove that they need ongoing protection. So even if they prove the first aspect that there was an act committed, they still need to prove that they need ongoing protection. So first you want to understand that and read what's needed to prove each different criminal action. But you also need to just find out what you may need to do to disprove that. And I don't mean just showing that's not true, but there's issues about the burden of proof, which means how much evidence the plaintiff or the person who filed needs to actually establish. You want to understand that. You want to know if it's going to rise to that level of domestic violence or not, so that even if an act did occur, it may not rise to the level. So you want to research what that really means and be able to use that. There are things called contratemps in New Jersey, which, well, I mean, probably most jurisdictions, but that really simply means people that fight with one another in relationships. It's a contratemp. So these are issues inside of the law that even if the person is able to prove the act of domestic violence occurred, and maybe even that they need the continuing protection, there still are ways to negate that and to sort of disprove it. Second thing you need to do is review the facts of the case. First, read the complaint, the temporary restraining order that you got. Make sure that you understand what is being stated in there, specifically, especially if it's detailed, all of the allegations, because you're going to need to be able to see whether or not they actually mention the allegations, whether they prove them. You may need to illustrate that they've missed or overlooked certain factors. You also want to check the dates and times. You want to then go back, to your calendar, to your iPhone, whatever it may be, and see if the dates actually match up, not just for their position, but for your defense. You want to make sure that the dates you're going to be talking about, that you're familiar with, what day of the week it was, what time of the day it was, where were you beforehand. This is probably the most important aspect, because in domestic violence, there's often no other witnesses than the people that are involved. So the judges will often have to go by credibility. They look at your body language, they look at your consistency, they look at your believability. So being able to recall, yes, this happened on the 23rd, it was a Monday afternoon, I was at home, is very important, especially if the person who filed isn't able to do that. A lot of times these are filed long time, or not filed, but they're heard long after they're issued. People forget the date. Sometimes they go and they're either distraught or they're confused, or it happens very late at night, so it gets filed maybe technically the next day. So it's important that you know these dates and that you're familiar with them when you get in there, so that when you tell your story, it's consistent. Last is practice telling your story. And don't practice with somebody that's very close to you, like your partner or your parent or a really good friend. Go to somebody that's really going to listen to your side of the story and tell you whether or not it makes sense. It's important to have practice telling your story. It's not just about defending yourself or telling the truth. And obviously you want to tell the truth, but it's how you tell the truth. Again, going back to what I said a moment ago, consistency, body language, eye contact, this is all important. But also it's got to make sense. The biggest mistake a lot of people make is to give a position that just doesn't make sense. Even if it's the truth, you got to be a little more objective. And obviously, again, I'm not saying to change your story, but for instance, if the allegation is you had this long drawn out fight, you had this horrible history of fighting and name calling and throwing things, and you had this blowout fight where the children were screamed at and you broke the phone and you threatened her this way or whatever it was, and you go in there and say, none of it ever happened. We've never had any problems. We've never had any fights. I completely deny it. Now, that may very well be true, and then that's obviously what you have to say, but it's probably not, and it's not likely that you've never had any problems. So if you go in and completely deny something that is so either egregious on the one side or such a long history, it's just not going to be believable. And a judge needs to understand the reality of the situation. Because again, going back to what I said in the very beginning, it doesn't just matter if you committed an act that's complained of. That may be true, that doesn't mean they get a restraining order. So you don't necessarily want to completely deny everything unless it's true, as I keep saying, but you want to be a little objective. You may believe none of it's true because it's exaggerated, but it's just not going to be believable. So you want to make sure that your story is believable and that it's consistent with how a person might act under those circumstances. For instance, I defended a case where the allegation was, I represented the husband, the allegation was the wife says that when husband came home from work at like 2 a.m, he threatened to kill her, took a knife, cut her hair, and then went to sleep. And our defense was that it just didn't happen. Now, and that was a little risky of a defense because the allegation was so egregious, you would think the judge would want to believe it and, more importantly, not want to send them home as husband and wife after it. But my argument was, it just doesn't make sense. People don't act like that. People don't come home from work at 2 a.m. and just all of a sudden make an allegation that they're going to rape you and cut your hair off. And she had the hair. It just didn't make any sense. So, and like I said, it was a risky defense. It was the only one because it was truth, and it was effective because it's not true. It wasn't true, and people don't act like that. So you want to make sure that you understand the law, what they have to prove, what you have to disprove. You want to understand the facts, both of their allegations and your defense, and you want to make sure that it's consistent and it makes sense with what would be like a reasonable person under circumstances that this would likely have happened. So I hope that helps you if unfortunately you find yourself defending against a restraining order. There are other videos I've done in the past along these lines on my YouTube page and my website, especially if you're in a divorce and you have a restraining order hearing. It's a much more significant issue, especially if there's children involved. So go to my website or my YouTube page for other videos on this. If this one was helpful, please like it and share it so that other people get to see it. I will be probably not on tomorrow, which would be the 15th, because I got meetings all day. But if I can, I'll throw a video on. I just probably won't advertise it. So with that, I hope you have a good day, and I will see you next time on